So my name is Eleni Kassaris. I'm a partner at the law firm of Cassels Graydon LLP. I think since about 2006 or 2007, I've been giving advice to Parkinson Society of British Columbia. Not only do I give them some advice specifically, but I've been doing a partnership with them where my firm, for matters that are within our bailiwick, that we can have legal advice for members when they have an issue relating either to employment or a human rights issue, and generally speaking, an issue that arises because they have Parkinson's. So my practice area is focused on labor and employment, and I primarily advise employers, but as part of the pro bono work, I flip it to the other side, to the employee side, and we've provided some duty to accommodate advice and some various advice over the years to different members relating to human rights, privacy law obligations, a little bit of disability issues, and things of that nature. So the good thing is that I have a lot of experience understanding this area and disability law in particular. And we have a situation where, because I kind of understand the lay of the land of sort of some of the symptoms with these types of disabilities and these types of diseases, I've had a chance to help a number of people over the years, including not only people suffering from Parkinson's, but also sometimes their family members when they have an issue that's arisen for them. Sometimes people with other similar, I don't want to say the word the same or similar actually, but other diseases that are difficult to manage in the workplace. I've had some success helping people get accommodations that have MS, for example, or CP. So with that kind of background, I wanted today to cover some of the things I've observed in my practice with relation to a few different categories. So most of the things I deal with are actually before there's a full-blown dispute with the employer. So typically, I'm a litigation lawyer. I will often have to deal with a full-blown dispute, either a human rights complaint or some kind of issue in the workplace. But there's lots of things that can happen before you ever get to a dispute. So even though I'll go through some of the rights people have if you have an actual claim and an actual desire to litigate, I want to talk a little bit about some of the managing the day-to-day issues with your employer if you have disclosed the diagnosis or haven't disclosed your diagnosis and are afraid to do so, if you need accommodation but you haven't yet had a chance to ask for accommodation or don't know what to ask for. And then sometimes people get afraid of the future. Unfortunately, symptoms can worsen, things can become degenerative, and you have to be concerned, of course, about some end-of-life matters, but also, when you're no longer able to work, what kind of rights do you have in terms of accessing private insurance that your employer might have or government benefits if your employer doesn't have those types of benefits. So I'm going to set the stage first before we talk about some of the categories in terms of legally what the rights are in the workplace. So we have the Human Rights Code, and the Human Rights Code is very simple in terms of what you need to know about it. So generally speaking, all protected grounds, and I'll give you a few examples, are protected from discrimination in services or employment. So a protected ground includes mental and physical disability, and then other things that we understand to be in the sort of ball of human rights. Your sexual identity, your gender, your religion, and so on and so forth. Ethnic origin, you can't be discriminated based on those things. Of course, if you have Parkinson's, the one that will probably come to bear in your work will be mental and physical disability. And specifically, Parkinson's has been recognized as a disability under human rights laws. It's pretty obvious that it's one of the ones that would be caught. So there wouldn't be an argument as to whether or not you have a disability. It's just whether or not the employer owes you duties, or a service provider owes you duties. So I'm not going to really talk about services today, but I'll touch upon it. If you ever felt that someone was mistreating you when you were trying to, buy a product or get a service from anywhere in town, because you have Parkinson's, they can see a tremor, or they're treating you oddly, or they're denying you a service, that's actionable under the Human Rights Code. We don't see those types of claims too often because it just doesn't happen as much as it used to. The classic example, of course, would be someone in a wheelchair doesn't have access to the facility, or they're denied service, or a person of color is denied service. So these things don't happen so often anymore in Vancouver. I'm sure they can happen, and I'm sure people have had incidences, but that's not something we see as the norm. What we see quite a bit is conflicts in the workplace. I think it's definitely a issue where we have an employer which may or may not be a sophisticated employer. It's quite possible that the first time they've ever had to accommodate anyone in the job is when you go and tell them, I need accommodation. And because of that, sometimes we have a situation where people stumble, people fail, people drop the ball on the duty. So what is the duty? The duty to accommodate disability is a significant duty in the workplace. The goal of that duty is to ensure that the person can stay as a productive member of the workforce for as long as possible. And it's not about necessarily giving you, 6 months off or a year off, although if that's part of getting you back to work, then that is something an employer needs to accommodate in terms of a leave of absence. So a lot of people misconstrue the notion as sort of guaranteed employment. It's not guaranteed for life, it's guaranteed to the point of undue hardship. So you have a situation where there's this test under our human rights laws that an employer must accommodate you in employment to the point of undue hardship. Now, the law has been very clear that undue hardship is a very high threshold to meet. So it's not going to be easy for an employer to say, well, we gave them a few days off and they can't really do the job anymore, and we tried to help them, but it didn't work, so we now have undue hardship. That's not going to be good enough. What will be good enough will be, I would say, a sustained pattern of trying different accommodations until something works to allow someone to be a productive member of the workforce. So the undue hardship standard is a powerful standard for anyone suffering from a physical or mental disability, because the law recognizes that the employer has to do quite a bit in order to make sure they're fulfilling their legal obligations. So because of that, you shouldn't be afraid or discouraged from asking for help or asking for accommodations. So the duty to accommodate sounds simple enough, but it can get a little complicated because the employer is not necessarily required to accommodate with the thing that is your favorite thing. So the law distinguishes between a preference and an actual accommodation. So we have had cases, for example, where individuals say, well, I can't really work on Thursdays. And that's more a preference than necessarily your doctor has said you can't work on Thursdays. And it may be that your doctor has indicated, I think you should only work reduced hours, or I think you should work only 4 days a week. And if your preference is not to work on Thursday, there would have to be something valid as to why Thursday is the key day, especially if your employer struggles on Thursday because Thursday they're short staff, or Thursday is a critical, month end type day, different reasons why they can't say, sure, we'll give you Thursday. So I would say that if you're asking for accommodation, which we'll talk about in a little bit more detail, there has to be some flexibility and some willingness to compromise on both sides. Because it may well be that the one thing that you think is the most important thing might be a preference and not actually, and there might be alternative accommodations that would work just as well. So I want to talk a little bit about managing your employer. So most things will not necessarily escalate to a full dispute, but you will face some challenges. And, as I alluded to before, most challenges come from a bit of a place of lack of understanding or education about not only what the person is suffering from, but also what the person's needs are and how the employer is supposed to be fulfilling those needs. So we have fear, a lot of fear. When the first time you have to tell an HR person, I have Parkinson's and I need the following things, people will be scared because they won't know what to do. And because they won't know what to do necessarily, they could say something a little bit ignorant or rub you the wrong way. And that's not okay. People need to do better. But if that happens, I would recommend that instead of starting a human rights complaint, you would try to work with your employer to help them understand where you're coming from and what you need. So I suggest to people they have to have a little patience as they're navigating through either disclosing a diagnosis or asking for accommodations. So you don't have to disclose your diagnosis to your employer. You can ask for accommodations without having a situation where you've told them you have Parkinson's. I find it is easier, and it's a judgment call, to get people on side if they know what's actually happening to you. Especially if you have a longer term relationship with your employer, it might just make sense to tell them. But the timing of that and what you want to do with that in terms of if you haven't told people your diagnosis, the issue becomes the issue is, okay, what is that timing? And that's really up to you. The problem that will arise is when you actually need accommodation, that comes to a head. So if you're sort of only have mild symptoms or no symptoms, but you've been diagnosed, you may not have to tell your employer for a long time. If your symptoms are advancing and you need some help from your employer, then you have to make a plan for telling your employer what you need. And that may likely include telling them you have Parkinson's. I think it's a good idea, it's a good strategy, because you are in a situation where you're being honest, you're trying to get some help from your employer, and you want to have that relationship continue. My understanding is the more you can stay active and employed, it's one of the things that would help you stay healthy and keep your symptoms a little bit at bay. I'm not a doctor, but I understand that keeping active is a big help for Parkinson's sufferers. So you want to stay employed as long as you can, and then you have a sort of conundrum. Okay, well, what do I ask for? So in consultation with your doctors should be telling you what you can do and what your employer needs to help you do. And then you'll have to have some documentation. So I would say that when you first approach your employer about accommodation, you would be ready with knowledge to give them information. Because people are at ease when they no longer feel stupid about something. So I would say be ready to explain what you need, what you're suffering from. Be ready to maybe put people at ease that, my symptoms are not very advanced right now. I'm able to do my job, but I have a couple of specific things I need to discuss with you. Like, be ready to give them some knowledge about some of the symptoms and what they can expect to see so they're not thrown off. I would not necessarily feel the need to give them the full information. That's not on you. After you've told them, they have a duty to figure out what they can accomplish in the workplace for you. I would have, some ideas of what accommodations are needed backed up with medical documentation. So you should say, I've been struggling. If your issue is, for example, fatigue, and you're very fatigued near the end of the day and your performance is starting to suffer and you feel you need to have different hours of work, I would have a plan that you can propose. And once you propose that plan, you might have to work with your employer on an alternative plan that works for you or works for them. But I would go into such a meeting or into such a conversation with some ideas. and some ideas that your doctor supports, because once your employer sees that documentation and they've had a chance to think about it and see what they need to do, it should go relatively smoothly. It's not necessarily foregone. Some people screw it up, and I have, unfortunately, a lot of experience with employers that in first instance do screw it up, but it can still be salvaged. And sometimes that means you get a lawyer, and the lawyer writes a letter for you about what their obligations are and what they should be doing for you. And that can clear things up. Now, to the extent it doesn't clear up, we'll talk a little bit later about the types of complaints that you might face. So accommodations, as I mentioned, are not about getting what you think is best for you. It's about getting something that allows you to continue to be a productive, hopefully full-time worker in the workplace, where you can continue to do your job and continue to sort of add value to the workplace and, add value to your own situation. So when you're asking for accommodations, as I mentioned, you need to be flexible, but you also need to be an advocate. So sometimes I think we face employers that want to shut it down. They're like, oh, we can't possibly do that. Well, I would say, why is it impossible? Because a lot of things are infinitely possible, especially in a larger workplace where there's a number of resources available to help make things happen. Some arguments are not very good arguments. Oh, we can't give that to you because it would open the floodgates or be precedent setting. In my view, those are dumb arguments because they have a duty to you to consider it for you, and for someone that's not suffering from a disability, well, they don't have to give them the same thing. So I'm not really sure what the floodgates are, except that they're expecting a flood of, Parkinson's patients, and they would have to accommodate each and every one of them. But the law is that they have to accommodate. So some things are silly, but people say silly things all the time. So I think you just have to be ready for counter arguments and say, well, why do you say that's impossible? And maybe you have examples elsewhere in the workplace. Susan is only part-time, and she's, as far as I know, doesn't have a disability. Why can't I be part-time, for example? So I wouldn't be afraid to advocate for yourself, but you also have to consider when you need help in advocating. So if you're backed into a corner and you're not really sure what to do, I would suggest that you do seek some legal advice. Now, everybody's afraid to talk to a lawyer because it's so expensive, and it's not every case that my firm can take on, but to the extent we can help, we will help on a pro bono basis. Sometimes we try to help people get pro bono counsel if we're unable to do the work for some reason. Access Pro Bono is an organization that does provide legal aid for individuals that have disputes of this nature. There's an application process, but it definitely could help. If you have means and you have some money, people think they're going to go bankrupt when they get a lawyer, but a lot of these cases, your accommodation issues can be dealt with in a couple of hours of work by a lawyer or a handful of hours of work. So it's not really prohibitive for some people. If you're a working person, you can afford a lawyer for a few hours. I'm not trying to say be light of it because it can cost significant money and eat into your savings potentially or something like that. But in the long term, it's worth having some advice when you feel stuck and you're not sure what to do. And sometimes it's good to get advice in advance. I've given a lot of advice on specific facts when people are saying, I haven't disclosed my diagnosis, I need to because I need a few accommodations, what's my best approach? And in an hour of time, they have a whole plan of what to do, and most times that works, and they go on about their business and I don't hear from them again. Other times it gets a little bit more involved. We need to do a couple letters back and forth, but then we can often solve the problem. Now, one area that has nothing to do with accommodation more than has to do with figuring out what to do for your future is the area of disability insurance. So if you're diagnosed with Parkinson's, there probably will come a time where you're unable to work and you need to access insurance. Now, if your employer doesn't have short-term or long-term disability, or it might be you have a flare-up and you need a period of absence, but you'll be okay and you'll be able to go back to work. One of those things. So some employers don't have short-term or long-term disability plans. Others do. And if you're changing jobs while you've already been diagnosed, you should ask questions from a new employer about what is in the plans. Ask for copies of the plan so you understand what they say. Occasionally there'll be a clause in an insurance plan, for example, which talks about how you're not eligible for coverage if you have a pre-existing condition for a period of time. So if you've already been diagnosed with Parkinson's before you start a job, as opposed to while you're in a current job, you might be disentitled from access to that private insurance. So you would need to figure that out because you might stay in your current job as opposed to take a new job that might be a little bit more exciting. So those are the types of situations that people that haven't been diagnosed with some kind of illness don't have to worry about. Now, while you are working and you want to understand your rights about your eligibility for LTD or short-term disability, you again need to understand the plan. And a lot of people, the only thing they ever see until they need something is like a plan summary. And the plan summary says, you know, you're eligible for long-term disability after being off of work for X number of weeks or X number of days on short-term disability. And it doesn't say much else. It just tells you, okay, and you'll be paid 2/3 of your regular pay, that type of thing. But there's underlying documents that are very useful for you to understand what will happen. Because, and I do see a question, I am going to address it now. You know, there's a question from Brian that says, I've been told that when I go on LTD that I should not reduce my workload, as if I go to 3 days a week. When the time comes to stop work altogether, then I will only receive 60% of my salary instead of 100% if I continue to work full-time. So that's a big consideration. So if you have, your accommodation is, I can only work part-time, one of the aspects of asking for part-time is, how does that impact my LTD benefits? Because I do understand that most insurance providers will have clauses in their plans that say it's your recovery for LTD will be X percentage of your then current salary or last year's salary or your previous 6 months of pay. So it'll be based on your most recent wages as opposed to your full-time pay if you're not working full-time anymore. So you have to be cognizant of that. And I would say that the decision will be based on, okay, so I've been working full-time for 10 years. Now I need to go part-time. How long before part-time turns into I need to go on LTD? Because if it's a short period of time and it's a stopgap measure, I would say it's not worth it. And you should probably consider whether you actually need to just go on LTD or go on a break with your short-term disability plan if you're unable to work your full-time duties. If you're in a situation where you might work for many years and can afford to live off your income at a part-time rate, because an employer is going to reduce your salary, they're not going to pay you full-time if you're only working part-time, then maybe it's okay to only get part-time wages under your LTD plan when the time comes. Because you have to balance, okay, I might be able to work 3 days a week or 4 days a week for the next 10 years versus the next 6 months, because I wouldn't compromise your long-term disability rights if the part-time work is a short period of time. And the only way you can figure out what to do is if you really understand the terms of your plans. So I would suggest to Brian and others, they should get copies of the full plan document. And they're very hard to read. It's very legalistic, but you know, you can either figure it out yourself or try to get some advice about what it says. And the best money you could ever spend because unfortunately I don't do a lot of disability insurance work because my firm is a big corporate firm that acts for a lot of insurers. But we try with the Parkinson Society to get you some legal advice from other sources. But if you can't and you need to spend, $1,000 getting to the bottom with a lawyer of what your rights are under that plan, that's the best $1,000 you could ever spend. And I know it sounds like a lot of money, but this is your entire, it could be age 50 to 65 that you need LTD. And spending that $1,000 when you're 49 is very much worth it in those circumstances. So you can't know what to do and what kind of accommodations to ask for or accept, because sometimes they try to push you to part-time work as well. And if you're not ready to do that, I would not agree to do that until you fully understand your rights with respect to your disability plan coverage. And it's a balancing act, and knowledge is power. So you really need to understand your plan. And we have someone that you can't make decisions until you fully understand the background. And I see that Brian's asking a follow-up about, do you know someone I can contact? Off the top of my head, no, but I would contact after this webinar the Parkinson Society to connect you. I think they have one or more people that does some disability law, and if not, ask them to ask me, and I have a couple people that I know do that work. But in the short term, I know the first thing your lawyer would ask you, which is, get me a copy of the full plan, not just the summary plan document. Because when you're hearing just so-and-so or some friend of yours saying, oh, I think this is what happens under the LTD plan, that's not going to be good enough. You need to read the document with a lawyer and make sure that you're covering yourself properly. So when you're talking about disability coverage and insurance and the future, it can be very scary because you have to understand that we are getting into sort of end-of-life issues eventually. So I would say that things that, although I don't do estates work, you do have to get your estate in order as well, sooner rather than later, because you want to be covering, your family's needs and what happens near your end of life and your final requirements when there's hospital issues, those types of things, which is unrelated to employment, but your coverage under disability insurance will sort of feed into, okay, well, I have life insurance. I designated a beneficiary 20 years ago when I first got my job. Maybe I should update that. Maybe I should consolidate it with my estate. Getting an estates lawyer to sort of help you navigate some end-of-life issues before you're anywhere near your end of life is powerful in the sense that you'll feel that things are taken care of. So if you don't have a will or you don't have a health representation agreement, which would guide family members on what to do if you were in hospital, I would highly recommend doing some of those things, and it should be informed by what you're getting from your employment, because, I recently did a will just because, and there were things I hadn't thought of. My lawyer was asking me about different documents that I would need, like a power of attorney, my representation agreement, asking me what kind of benefits I have through my employer in terms of accidental death and dismemberment, other types of life insurance. I didn't actually know any of the answers to the questions about what I get through benefits, because you sign up for benefits when you start a job, and you use your little card to go to the dentist or to go and get a prescription, but you don't really turn your mind to some of the underlying things that are also included, and there's ways to designate beneficiaries and deal with those issues. So for me, it's all part of understanding the full rubric of what is available to you, including the terms of your long-term disability plan or your short-term disability plan, and then getting your affairs in order type of thing way before there's a crisis. because you want to be ready for when there is a crisis, like, oh, I need to go part-time, or I can't work late anymore because I'm too fatigued. I need my employer to accommodate an earlier work schedule, for example. You're ready because you've done all the homework, so to speak, in terms of what your rights are vis-a-vis that employer. Now, sometimes you do not have coverage under long-term disability, which means that you might be to the point where you're permanently disabled and you need to access Canada Pension Plan benefits. This is also another, and I'm specifically referring to the disability benefits that you would access before age 60 or before age 65. And this is another minefield that, honestly, I don't have a lot of firsthand experience, although we've had opportunity to help a couple of members over the years navigate the government world. And I would recommend that you get some help navigating that world. If you think that you need to apply for disability benefits from the government, the timing of those benefits in comparison with when you would get access to your retirement benefits, there's some nuances in there that escape me, but I know that they can be a little bit of a minefield for people suffering from a disability to access those benefits, because it's just a lot. It's just a lot of different bureaucracy, and it would help to be sort of get your orientation, figure out as much as you can, speak to a lawyer if you need to before you apply, because there might be a timing issue that it might be better for you to wait to apply if you're able to work. We had a member that had quit her job and then was trying to apply for disability benefits. And there was something about the timing between how she had quit her job and then had applied for disability benefits that had the application denied. I don't remember all the details because one of my colleagues handled that matter, but we appealed for her to an appeal board of CPP and won that appeal. But if she had talked to us beforehand, she could have avoided the initial rejection, I think, by just dealing with the timing issue a little bit better. So there's different things that you have to be concerned about and make sure you have a full understanding before you're trying to do anything, because if you make a wrong move, it could impact the timing of being able to receive additional benefits. So I've talked a little bit about different considerations, but I do want to talk a little bit about, okay, well now I'm sure my job is in jeopardy, or I might get fired, my employer no longer wants to accommodate me, or they're discriminating against me and they're treating me poorly. What do I do? So if things have escalated and you're not getting proper accommodations or proper access to your benefits and you're not sure what to do, your only legal resource would be a litigation option. So, and all of those options are stressful and intimidating, and no one wants to really think about them. But if you have a situation where you are backed into a corner and you don't know what to do next because you're being mistreated and you think you're going to get fired, or you have been fired and you think it's related to your Parkinson's, or they're refusing to accommodate you and they're mistreating you, then it might be that your only course of action is a human rights complaint or a civil claim of some sort. So what does that look like? Well, it can be a long process. It can take you a couple years to get your rights vindicated. But we do have the Human Rights Tribunal, which is meant to be a self-help tribunal, but again, if you can get a lawyer to help you where it's either pro bono or it's not breaking the bank because you have a cost estimate that you can afford, it can be helpful because it is a very stressful environment. But it is meant to be self-help. There's a form online at the Human Rights Tribunal website, which if you Googled BC Human Rights Tribunal, the first link would be their website. And they have a list of forms, and you can file a complaint. And it is very straightforward. It's just a form that says, you know, what happened, when did it happen. You would do it in your own words. And the tribunal will then facilitate a complaint process. Now, the complaint process is not that complicated in the sense that they usually want to do an early settlement meeting. And the early settlement meeting can be very helpful because if you are currently employed, they can't fire you while you have a human rights complaint. I mean, they can, but it would worsen their position, so most employers would not fire you if you have a pending human rights complaint against them. And it can be a very good meeting in the sense that it's basically a mediation where you can clear the air and try to get some closure and maybe go about your business. Something like, I forget the exact statistic, but it's definitely over 80%. So 80% of all human rights complaints settle at this early settlement meeting. So that could be a way to sort of force your employer to focus in a way that they haven't focused before, if they're messing with you, if they're not playing ball, if you think they're violating your human rights. Now, there's still the 20% that don't settle. So if that happens, the next thing would be a tribunal hearing to deal with the complaint. And there you would need to present evidence on why you believe you've been discriminated against. And the employer would present a defense, and then a tribunal member would decide whether or not you've been discriminated against. Now, in the human rights world, if you've been fired, they have the ability to reinstate you. But for the most part, they're going to be awarding damages. So lost wages damages to the date of the hearing, and then another sort of bucket of damages that we call injury to dignity damages, which relates to punishment basically of the employer for failure to accommodate. Unfortunately, if you're at the point where you're in a really complicated, long human rights matter with your employer, the relationship has degraded, your health has probably worsened. It's not ideal. So I would suggest that even if you have to do that step, try to be open to sort of settlement options along the way and see what's best for you. Because at the end of the day, you have to do what's best for you. And going all the way through a big hearing might not be what's best. But it might be necessary. It might be the only way for you to get any justice at all. So these avenues of redress before tribunals or the courts are available. A civil claim would be more based on if you've been fired, as opposed to if it's just discrimination because of a jurisdiction issue. But if you've been fired and they haven't paid you properly and you have a belief that they've mistreated you because of your Parkinson's or otherwise, you might be able to pursue a court claim as opposed to a human rights complaint, which would include a component for trying to punish your employer and trying to get punitive damages. But again, if you're at that point, you're in a situation where things have escalated to the point where you're either unemployed or struggling to keep your job, and it's terrible. So I would hope that we could negotiate something much earlier in the process before there's an escalation to litigation, but sometimes things spiral and your only redress is litigation. And if you're in a unionized environment, it might be easier in the sense that the union would bring a grievance on your behalf and it wouldn't cost you any money because you're already paying your union dues. But the stress would be the same because you're sort of in limbo a little bit until the court process or the grievance process or the complaint process has sort of run its course. So on that high note, I would hope to take a bunch of questions. We had one from Brian, but I'm happy to take more questions about kind of anything that people want to ask in the field of employment law, duty to accommodate, those types of things.
Great, thank you so much.
I see multiple.
Great, thank you so much.
Multiple people are typing, Miriam.
Yes, exactly.
It's great.
Exactly. Yes, exactly.
So I would say that if you're, I talked before, while I'm waiting for some questions to come up, I talked before about doing your homework. And doing your homework really is important. You need to do your homework on the long-term disability plans. You need to do your homework on making a plan for disclosing your diagnosis, or asking for accommodation. Another area would be understanding litigation rights. So if you feel that you've been discriminated against, or you might face discrimination in the workplace, there are a lot of resources on that Human Rights Tribunal website that you can read about to get sort of an orientation about what I'm talking about. So that would be another avenue of homework to do when you have time. And I know time is a hot commodity, but that's something. So I have a question about retirement and income tax disability after diagnosis. Can you address? I'm going to need a little bit more because I don't really understand what the question is. I'm going to need a little bit more. So we'll take a different question while Eric is addressing a little bit more there. Oh, yes. So I don't believe there are. I think that the disability, oh, I see. So if there's deductions, there are some deductions that are viable under income tax law. So Eric's follow-up was, diagnosed after retirement, is there disability tax benefits to be applied for? So my understanding is that the Canada Pension Plan disability benefits are only until you're 65. In terms of other tax credits that you might be able to claim, there are some, I think, for medical benefits that you probably won't have private benefits that would cover them, so you could claim tax credits of some sort. But I'm sorry, I'm not familiar with them in any great detail. So we do have, Miriam has posted a link to the CRA's website. I would say that talking with an accountant or a financial planner about what kind of things you can maybe do to structure some of your taxes after retirement as a result of your diagnosis is a good place to start. Yeah, I would say for tax issues, try to find people that are not tax lawyers, because tax lawyers are very expensive. And I think an accountant or a financial planner or an investment advisor can assist with those types of questions to some degree. But if it becomes more complicated, then you might have to get a tax lawyer or be on hold for a very long time until you try to figure it out directly with a CRA individual. So Todd posted that he was told as soon as that you told your employer as soon as you were diagnosed 4 years ago, and the employer informally accommodated, but your problem was you wanted to be off and not be accommodated because you knew it would not work, so you had to fight. Well, I think it would be useful for others on the webinar to understand the fight. I would understand that you wanted the time off, and there would be a struggle potentially between your medical documentation and the employer's view of it. And unfortunately, if you were trying to access long-term disability benefits, you would get into a situation where potentially the LTD provider, they don't just hand out benefits. If they think that you can work, they will try to get you back to work. So in my view, even though I'm sure you've already been through quite a bit, and there's potentially an outcome as well, getting the doctor information to be detailed and on-site as to why you can't work or the accommodation is not sufficient and you need to go off would be a strategy there. But I know that that's a difficult issue when you disagree with the decision makers about whether or not you should be off work or working and accommodated. So Brian has a good question. So the question is, I know there are some among the people who employ me that would like to be rid of me for reasons I do not wish to discuss publicly. Is it advisable to go to my employer who has known of my diagnosis for a year now and perhaps offer to go on LTD, say for a year's salary? Or is that a conversation I need to have with a lawyer? I do think you should have a conversation with a lawyer. And the reason for that is you want to make sure that any deal you make with an employer, I agree with you. Employers get fatigued. They like to close things out. I have an employer client of mine right now that is just very antsy to deal with someone who's been away for only a few months. And I'm like, well, you need to have patience because this person we know is coming back, or maybe they won't come back, but there's nothing you can do to force the issue. So I do believe that a lot of employers, for whatever reason, they have a mentality that they want to sort of clean up issues that they perceive to be in the workplace. And I'm sure you're right that they want to get rid of you because some people feel that way and they want closure on issues. If you're going to negotiate with them, I think you should really consider how that will impact your LTD. Because if you are not already in the LTD system and you receive a package, you might be disentitled from applying for LTD. Alternatively, if you are on LTD and then you receive a package, it could affect your LTD benefits. Because the issue for you is not, can I make a deal with my employer to be paid out? Because you can. But the employer and the insurer do not work together. They have separate contracts with you, so to speak. The insurer has a contract with the employer, but they administer their own program. So I would want you to have some advice about, okay, well, if I do this, what are the ramifications on the other side of the table? So I would say that if you want to be packaged out, you need to fully understand how that might affect your LTD. And the fact of the matter is, if they want to get rid of you and they're struggling with how to approach you, if you approach them, that'll be great because they'll give you some kind of offer. But you still need to make sure you evaluate the offer properly. And don't be surprised that sooner rather than later they approach you anyways, even without your instigating anything. But in the short term, I would say legal advice for sure on that one because it can get complicated. So I have another question from Rob. Rob is saying, I believe my long-term disability insurance states that I'm eligible for LTD if I'm unable to do a certain percentage, say 60% of my full-time job. How is this determined? I don't really know the answer to that question. I would say that if you're unable to do the majority of your work, you would apply for LTD and then they will do some kind of evaluation. Now, remember, your insurance companies are still insurance companies, so they like to say no to the provision of benefits, and that's when you have to fight. I would say appealing an insurer's decision is par for the course of getting your full-time benefits from an insurer. So just make sure that if you feel that you can't do half your job and you need to go on LTD, I would say you apply in good faith. This question is, I've been working 4 days a week since February 1, 17, applied for LTD with RBC Insurance in October 17. I had 1 hour phone interview with the insurance company a few weeks ago. I'm now going down to 3 days a week on March 1, but still have no answer from RBC Insurance. Any suggestions to help this process move along or get approved? Yes, the delays. So the delays are real. They can last quite long. Insurers don't feel a lot of pressure to move quickly. So I would say, call them back, give it a few goes of trying to harass them. Harass is a wrong word because it implies wrongdoing, but you know what I mean. Be a bit in their face to get a decision, and follow up a few times and see what happens. And if that doesn't work, then you might need to get an advocate write a letter regarding this delay and how it's impacting you. So then, but I think you have nothing to lose to be a little pushy to the extent you haven't already been, and just try to get their attention. And it might just be sitting on someone's desk and they haven't looked at it for a long time. So it's worth a shot to just follow up as many times as you can. And then I have a question from Robert. My earnings have peaked, and if I request any accommodation in terms of shorter work week or shorter days, or even another position, I would then be reclassified in a position which would reduce my LTD benefit. I pay the premiums to my employer, as I have been paying for the higher benefit. How do I avoid reducing my benefit level while still trying to work? In general terms, can an insurance company start a claim and allow one to continue to work? I don't think so. I think the insurance company will only accept the claim if you're unable to work. So this is where a lot of homework and digging comes in to make sure that it's difficult because I know, you're talking about reclassification, so you're in a unionized environment. The union environment is very tricky, as I know you have experience with, Rob. And I'm sorry, I apologize, but I just don't know the answer to that question. But I would think a lot's at stake because you don't want to reduce your LTD benefit because you've been paying into it for so many years and you've earned it. And maybe it's a situation where 3 days a week just doesn't cut it and you choose to apply for LTD benefit instead and see what happens from there. But to be honest, I'm not sure what to tell you because that seems like a complicated issue to me, and you might need some specific legal advice looking at your collective agreement and looking at different things that apply to you and what you might be able to do.